Will I get the money and when will I be paid are two of the questions we get regularly asked by creditors. And the answer to that many times is dependent on the estate we're dealing with and what assets we are dealing with. And sometimes there are very few assets, but then the sort of action that an insolvency practitioner can take against the more culpable parties could enhance those assets. So a lot of it will depend on, is there any money there in the first place? If there is, and that money is realised, you then have statutory rules that govern the order in which that money is dispersed. And in general, you'll have your secured creditor, such as a mortgagee, over a property, for example. You'll then have your costs of the administration, preferential creditors, and that's not to be confused with revenue and customs. It is more arrears of pay and holiday pay due to former employees. You will then have another form of security that comes in called a floating charge before any money reaches the general body of creditors, where it is dispersed in an equal manner, pence per pound or pari passu, as the law calls it. So unsecured creditors can be fairly low on that order of priority. And this is why insolvency practitioners always ask, can you help us? Tell us what you know. Creditors also have to think about what other areas they have. They may have directors who will commonly forget that they have given them a personal guarantee. Provided you have signed documents, you have afforded them the opportunity of independent legal advice, then if you have that guarantee, you can ignore the insolvency process and pursue the guarantor. Equally, if it's a partnership, partners are jointly and severally liable, which means you have a right to sue those partners. It may be one of them's got money and the others haven't, so you can just pursue the one with the money.